The 14th Amendment states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. The 14th Amendment prohibits states from depriving any person of liberty without due process of law. It also requires that states guarantee equal protection of the laws. The Supreme Court long has interpreted liberty to encompass much more than freedom from physical restraint. It has also recognized that some liberties are so fundamental that no possible legal process could justify their deprivation. In 1967, when it struck down state laws banning interracial marriage, the court cited both of these provisions. Chief Justice Earl Warren wrote that Virginia's anti-miscegenation law violated the Equal Protection Clause because it involved invidious racial discrimination. It offended the Due Process Clause because the freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. The same considerations argue for a decision striking down bans on same-sex marriage. Although the 14th Amendment was primarily intended to secure legal equality for freed slaves, its guarantees are couched in general terms that can accommodate new social circumstances. The court has used the Equal Protection Clause to uproot gender discrimination as well as racial discrimination, and the clause is equally applicable to discrimination on the basis of sexual orientation. The court should interpret a constitutional freedom to marry in light of the increasing realization that marriage includes loving same-sex couples.
The 14th Amendment protects LGBT rights such as same-sex marriage and gender-equal bathrooms.
The debate was around the 14th Amendment ensuring that everyone has equal protection under the law, and if you limit gay and lesbian couples' ability to get married by placing different laws on their marriages, that means that they don't have equal protection as straight couples.
In June of 2015, the Supreme Court of the United States ruled that marriage equality is legal in all 50 states under the 14th Amendment. The Supreme Court justices found that under the 14th Amendment, all states must recognize same-sex couples and allow same-sex unions. Along with the protection of LGBT rights, the 14th Amendment ensures women have the right to pregnancy contraceptives or abortions.
In Roe v. Wade, the court established a right of personal privacy protected by the Due Process Clause that includes the right of a woman to determine whether or not to bear a child. In doing so, the court dramatically increased the judicial oversight of legislation under the privacy line of cases, striking down aspects of abortion-related laws in practically all states, the District of Columbia, and the territories. To reach this result, the court first undertook a lengthy historical review of medical and legal views regarding abortion, finding that modern prohibitions on abortion were of relatively recent vintage and lacked the historical foundation which might have preserved them from constitutional review. The court then established that the word person, as used in the Due Process Clause and in other provisions of the Constitution, did not include the unborn, and therefore the unborn lacked federal constitutional protection. Finally, the court announced that the 14th Amendment concept of personal liberty and restrictions upon state action includes a right of personal privacy or a guarantee of certain areas or zones of privacy, and that this right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy.
The right women have to receive birth control through insurance is protected through the 14th Amendment, more specifically the Due Process Clause. In Griswold v. Connecticut in 1965, the Supreme Court ruled that a Connecticut law forbidding individuals from using drugs, instruments, or pharmaceuticals as contraception for pregnancy was unconstitutional because the due process law ensures the government will retain a person's human rights and liberties. Because of this verdict, access to birth control is a privilege for the United States citizens. As stated in the 14th Amendment, no state shall make any law which shall abridge the privileges of citizens in the United States. This means that Trump's actions to eliminate women's guarantee of birth control coverage in October 2017 goes against the 14th Amendment by revoking women's privileges. More than 55 million women have access to birth control without co-payments because of the contraceptive coverage mandate, according to a study commissioned by the Obama administration. Under Trump's new regulations, hundreds of thousands of women could lose those benefits.